Good afternoon, Facebook. Tim Anderson here. Today is Monday, the 9th of December, 2019. Many of you have asked, just tell me the truth. What is it going to look like next year? What is going to happen when the laws kick in? What are the courts going to do? What is the analysis? And so many of you believe that these laws are unconstitutional. Many of you believe that banning assault weapons without a grandfather clause violates the ex post facto clause. Many of you believe that it's a taking. Many of you believe that it's an infringement on the Second Amendment. But let me tell you something, and whether you want to hear it or not, I like to tell the truth in all of my videos, and this is something that you're probably not going to want to hear. We are in the Fourth Circuit of the federal court system. Virginia is. And what that generally means is that there's these federal courts have different circuits, like the first, second, the third, fourth, fifth, whatever. We're in the fourth. Now, about a year ago, in 2017, the Fourth Circuit Court of Appeals addressed a case called Kolbe versus Hogan. And what it was interpreting was Maryland's assault weapons ban and high-capacity weapons ban. And in a 100-plus page opinion, the Fourth Circuit Court of Appeals found that the ban of assault weapons in Maryland, which are basically, they defined as military-styled type of weapons, which include AR-15s and all the things that people are talking about in Virginia, that meets all of the constitutional standards and is not an ex post facto, is not a taking, is not a violation of the Second Amendment. And you have to understand that, because when Virginia passes the Senate Bill 16 or some kind of variation like it, when lawyers run to federal court yelling, this is a violation of the Second Amendment, you can't make felons out of people overnight, the district courts, the federal district courts, are bound by the Fourth Circuit's opinions, and they will be bound to rule in favor of how Kolbe versus Hogan was ruled, which basically says those laws have to be examined under what's called intermediate scrutiny under the Heller test. And all that the state has to prove is that it has a compelling state interest to restrict certain types of firearms and restrict magazine capacity. Now in Maryland, it addressed both magazine restrictions and assault weapons. And look, I'm not trying to say assault weapons tongue-in-cheek. I'm talking about what the legislature is saying. So if you want to know what's going to happen, these laws are going to pass. The federal courts are not going to be on our side. And so what can we do as citizens? Well, the first thing is we're not going to see the federal courts jump in and issue injunctions, because Kolbe versus Hogan will apply. So when these laws pass, you are going to have to accept the cold hard reality that if you possess a prohibited firearm after the deadline, they're going to say July 1st or whatever date they're going to say, if you possess the firearm, then you're going to be a felon. You're going to be deemed a felon under Virginia law. Now, whether sanctuary cities will maybe not enforce those laws, however that is, you're going to be committing a felony in Virginia, just like you would be if you were in Maryland, just like you would be if you were in New Jersey. And so when these laws change, you're going to have to really think about whether you want to be committing a felony. These have not, I've seen the Marbury versus Madison posts where, we don't have to follow repugnant laws. The courts have addressed this. The highest court other than the Supreme Court of the United States in our district has addressed this and said that not only are these laws lawful, but they're not in violation of the Second Amendment. They're not in violation of ex post facto laws. They don't exist. And so you have to understand that the law is not going to, there's not going to likely be injunctions against these laws, even the ones without grandfather clauses, because they don't have grandfather clauses in New Jersey, and they don't have grandfather clauses in Maryland. So you're going to need to be looking at either modifying your weapons or your magazines to be in compliance with the law, or you're going to have to remove them to be in compliance with the law, even if you're in a sanctuary city. Please understand that. Now, to my friends at the VCDL, who I hope are watching, who are probably going to take most of the lead here, we have to come up with more creative ideas other than running in and saying this is a violation of the Second Amendment, or this is a violation of our ex post facto laws, or this is a violation of a taking clause of the Fifth Amendment. Coming in and doing the same thing is going to end up in the same result, which is losing. So I have some ideas, and I hope that you at the VCDL are watching. And if you are members of the VCDL, I hope that you will encourage them to collaborate with me. If you are a lawyer and you're watching this and you have ideas, share them so that we can come up with a different way of attacking. But running into court, yelling Second Amendment infringement, yelling ex post facto, yelling taking, yelling you can't make felons out of law-abiding citizens, all of that has been tried and all of that has been failed. Now, I will say this. If there's any glimmering light here, there is the case of Warman versus Healy. And Warman versus Healy is a case from Massachusetts that is before the Supreme Court of the United States. Now, the Supreme Court has not accepted cert on Warman versus Healy, but everything is queued up. All the deadlines have passed. If the Supreme Court accepts cert on Warman versus Healy, it is going to definitively answer whether or not citizens of the United States can own AR-15s and high-capacity magazines in reference to the Second Amendment. See, the problem with Heller, the main case here, is that Antoine Scalia said that we're not allowed to have unusual weapons that are military grade. Essentially, that's what he said. May not be quoting him exactly. And what the courts are doing is they're saying AR-15s fall into that unusual military exception that Antoine Scalia carved out in the Heller case. And so that's how the courts are getting away with all of this. Now the Supreme Court's going to have the opportunity to clarify what it meant. Two things are going to happen at the Supreme Court. They're either going to say, yes, we're going to take certiorari, then the case is going to be decided, or they're going to say no. If they say no, case is over, and we will have no Supreme Court precedents on this, and we will be bound by the Kolbe versus Hogan case. If they do take it, then they're either going to say yes or no of whether we can have higher capacity magazines or whether we can have weapons like AR-15s. It will require the Supreme Court to decide Warman if we have any chance in Virginia of being able to keep either higher capacity weapons or the like. But until then, whether the court even takes Warman versus Healy, you should be thinking about where you're going to move your firearms. They should be moved to North Carolina. They should be moved someplace where they're legal, because if you keep them in Virginia, even in a sanctuary city, you will be subjected to felony prosecution, and you have to understand that. I know you don't like what I'm saying, but that's where we are, and I'm trying to let you know what to expect. This is a devastating case that's been on the books now, and until the Supreme Court steps in, we are going to see rules in Virginia that are very identical to Maryland, very identical to New Jersey, and they're going to make the sporting rifles, modern sporting rifles, illegal. They're going to take away our capacity issues on higher capacity magazines, which means you're going to have to take your magazine out of your gun and throw it away and buy a magazine that holds 10 or less to be in compliance with the law. You're going to have to do those things, otherwise you're going to face felony prosecution. I know I'm seeing the comments. I know you don't like what I'm saying. but I'm trying to give you the truth because you need the truth. If we want to do anything right now, we must show up at these city council meetings. We must convince our leaders to approve sanctuary cities. And by doing that, we can possibly persuade Richmond to back off on some of these rules. Maybe we will, maybe we won't. But this is a political fight. When these rules go into effect, we're not going to see the federal courts intervene. Even though there's no grandfather clause, even though it would make ownership of a weapon you have today a felony to possess it in the future, those arguments have all been tried, all been failed, and all been addressed in the Kolbe versus Hogan case. I've posted that case here for you to look at. Please look at it. If you know some lawyers, have them contact me. If you know the VCDL people, talk to them about what their strategies are, because we can't just make the same arguments and expect a different result. I hope that helps, Facebook. I'm sorry for the bad news, but show up. This is the time to stand up. Show up and talk to the locals. Show up and get them to send messages that we don't want these laws, and maybe some more moderate Democrats will soften up. I hope that helps. My name's Tim Anderson. I will see you next time.